Well, happy Tuesday morning. It's going to be a big week when it comes to litigation against Illinois' gun and magazine ban. Already a lot of filings to go through from the state, from Cook County, from the city of Chicago, all in anticipation of Thursday's hearing that will be streamed on YouTube from the U.S. Circuit Court of Appeals for the 7th District out of Chicago. So we'll walk you through how to access that when it does go live Thursday morning. But before we get there, we got to just get that background before we review what's going to be happening Thursday. So, of course, Governor J.B. Pritzker enacted a gun and magazine ban on January 10th. It was passed by the previous legislature within the final hours of the legislature, the 102nd General Assembly in Illinois, right before the 103rd General Assembly goes into effect. That was on January 10th when the governor signed that at the Capitol. It bans over 170 different semi-automatic pistols, rifles, and shotguns. And it also includes a whole bunch of accoutrements from pistol grips to barrel sheaths to a whole host of things. It also bans the possession and sale of magazines over 15 rounds for handguns and over 10 rounds for rifles. It also creates a registry to require individuals who owned these now banned weapons to register those with Illinois State Police. They're going to open that registration window by law on October 1st, and then there's a deadline of January 1st to register your firearms with state police, or you could face criminal penalties. Now, this was challenged on the grounds of it violates the Second Amendment. You also have other challenges still out there concerning the Fifth Amendment rights of, not having to self-incriminate yourself by telling the government that you have a banned weapon. That particular challenge still on hold. They're just going after the Second Amendment issue. So you had lawsuits filed in federal courts and in state court. We're still waiting in state court for the outcome of Dan Calkins' case out of the Illinois Supreme Court and how that'll impact the cases that Attorney Thomas DeVore has. So that's state court. But in federal court, you had the plaintiffs all combined down in the Southern District of Illinois federal court, involving the Illinois State Rifle Association, the National Shooting Sports Foundation, the Federal Firearms Licensees of Illinois, and also a case called Langley from Attorney Thomas Magg. All four of those consolidated in the Southern District. Now, while that was happening in the Northern District of Illinois, you had a challenge against Cook County and Chicago's gun ban and also against Illinois' gun ban. That case was heard and ultimately decided in favor of the state and local gun bans in the Northern District. In the Southern Districts out of East St. Louis, a judge there in that consolidated case issued a preliminary injunction against enforcement of the law, essentially saying the law was on hold while the case continued to progress. Well, the states went to the Seventh Circuit Court of Appeals in Chicago, asked for a stay of that preliminary injunction. That stay was approved, and then they eventually consolidated all these cases into the Seventh Circuit Court of Appeals with an expedited briefing schedule, and the hearing is going to be on Thursday of this week out of the Seventh Circuit Court of Appeals. So that's where we're at right now, right? Earlier this month, the state filed their initial filings in the appeals court. Then a few weeks later, last week, you had plaintiffs file their briefs. And essentially, the arguments boiled down to the state says these are dangerous weapons and they need to be regulated. It's much more sophisticated technology, making them more dangerous and lethal. They also say that criminals use these semi-automatic firearms, and the increase of mass shooting instances is the impetus the state uses to ban these things. The plaintiffs say, look at the U.S. Supreme Court ruling from a year ago in New York State Rifle and Pistol Association versus Bruin, where the Supreme Court said that judges and courts have to review challenges to gun laws looking at the Second Amendment text, history, and tradition, and that you cannot ban commonly owned firearms. So plaintiffs essentially just put that argument back out there against the state with all of their what is called balancing of interest approach to finding the constitutionality of a law. So again, state filed their briefs earlier this month. The plaintiffs filed their reply briefs, and now we have another set of briefs from the states that will look at the docket here from the Seventh Circuit Court of Appeals and make sure we got this queued up for you. And really, it's fascinating just how much has been put into the docket just yesterday. All right, So looking at this, you've got a whole bunch of filings and things that are being put to the court in anticipation of Thursday's hearing. And I do want to just highlight some of this. So yesterday you had the Cook County filing, you had the City of Chicago filing, and you had the State of Illinois filing. So looking at these filings, you've got the reply briefs, and just looking at the arguments in reply to what the plaintiff said. We'll go ahead and pull that up here. It says evidence of common possession does not satisfy Herrera's burden to show common use. Interesting. Evidence of common possession doesn't show common use. The state and governments, really, they also argue assault weapons, they say, are fundamentally incompatible with the limited doctrine of self-defense recognized at English common law and are thus outside the scope of the Second Amendment's protection, they argue. And again, these are just the distilled bullet points they're arguing in their initial filing here, right? In the first few pages as an overview. Gunpowder regulations, they say, demonstrate a long-standing tradition of regulating arms responsible for mass casualty events. Spring gun regulations demonstrate a long-standing tradition of regulating firearms incompatible with lawful self-defense. And Herrera was waived any arguments regarding the application of the nuanced approach to unprecedented social problems. So again, still kind of seeing some of that balance of interest, and whether or not the court's going to see that as a legitimate argument, we shall see. Here we've got the state in their reply to the case and their bullet points. They say assault weapons and high-capacity magazines are not in common use for self-defense, they argue. And I think, one of the pushback against that is who's to determine what's used for self-defense and who is to tell somebody what's used for self-defense. They go on to say, quote, assault weapons and high-capacity magazines are dangerous and unusual, and the city's ordinance is consistent with the nation's historical tradition of firearm regulation. So that's another kind of table of contents from a brief, and then to the Caleb and Barnett plaintiffs from the Southern District. You've got the government's filing here that says plaintiffs failed to show that assault weapons and large-capacity magazines, LCMs, are protected under the plain text of the Second Amendment. They say large-capacity magazines are not arms. They say plaintiffs bear the burden to show that assault weapons and large-capacity magazines are in common use for self-defense today. They say assault weapons and LCMs are not in common use for self-defense. Very similar to what the Cook County and City of Chicago were arguing. They also say that in any event, the Act's restrictions on assault weapons and large-capacity magazines are consistent with the country's tradition of firearms regulations. So again, you can see here where they're really distilling down their arguments, right? And that's just the table of contents. If you want to get into all of the really heady, the real fine points that they're arguing in their briefs, you're going to have to get copies of this. And I know the Firearms Policy Council or Coalition, FPC, they have these documents as well on their website. But you look back at the docket here, and it's not just the briefs that were filed by Cook County, by the City of Chicago, by the State of Illinois. You have amicus briefs being attempted to be filed here. Including, I saw here where it said like 22 states were going to be filing amicus briefs or attempting to. So you've got an attorney with the state of Idaho and 22 other states. They want to try to file an amicus brief. They also have amicus briefs from the Second Amendment Center, Gun Owners of California, California Rifle and Pistol Association, State Line Rifle Association, DeWitt County Sportsman's Club. So a lot of different attempts to file amicus briefs. And I'm curious because at first, one of the docket entries that announced the consolidation and also the timing of the briefs, it said that there would be no amicus entertained of sorts. But again, if you look at the docket, you can see here, state of Idaho, 22 other states. You've got Second Amendment Law Center, Gun Owners of America, California Rifle and Pistol Association, State Line Rifle Association, DeWitt County Sportsman's Club, Gun Owners of California, and so on. So, yeah, a lot of amicus briefs looking to be filed here in this case. Now, this is the last round of filings before we get to the hearing on Thursday. Stay tuned because I'm going to show you how you can access the live stream of the hearing Thursday, so you could sit there, get your popcorn, get your soda, and just take it all in. It's not going to be a video stream, it's just an audio stream, but that should be plenty. So I'll walk you through how you can access that here in just a moment. All right, back at it to tell you how you can tune in to the Seventh Circuit U.S. Court of Appeals hearing Thursday on the challenge of Illinois' gun and magazine ban. Again, went through all the background last segment, overviewed some of the table of contents of the state, Cook, and Chicago governments' filings that were filed yesterday, a review of just some of the Amicus briefs that are being filed as well. But let's tell you how you can get access to the Seventh Circuit Court of Appeals oral arguments. So just go to the Seventh Circuit Court of Appeals. All right, search U.S. Court of Appeals, Seventh Circuit. You'll be able to find their official website, all right? It's ca7.uscourts.gov. The United States Court of Appeals for the Seventh Circuit. Now, under oral arguments, if you click on oral argument videos, you click there, and then you can see, opinions and oral argument audio recordings. But then you'll see oral argument streaming arguments on YouTube. Hey, it's new. So you click through that, and you'll notice something here. There's nothing on the home page, all right? So this is the Court of Appeals, Seventh Circuit for the YouTube channel, all right? There's nothing on the home channel. Why? Because everything they do streams live. So you got to click over to the live feed. And here is where Thursday morning, 9:30 is when they're supposed to start. So I would recommend you get in there just so you can make sure you see it pop up. Refresh it several times just to see if it pops up. Refresh it, see if it's live. And then when it goes live, it should show up in this live category, not the home category. Should show up in the live category. So just a little tip for you if you want to tune in. And I know that a lot of people are interested in the actual oral arguments. When I was in the Southern District Court tweeting out the oral arguments, there wasn't a live stream or there wasn't a teleconference line. But when I was tweeting out all of the various points that I could at a rapid clip, I mean, those tweets were shared far and wide. So there's a lot of interest in the oral arguments. You'll be able to tune into those oral arguments through the U.S. Seventh Circuit Court of Appeals via their YouTube channel. And again, just to walk through how to get there, it's pretty simple. You just got to search U.S. Circuit Court of Appeals, 7th District. And when you get there to their official website, underneath oral arguments, you'll see oral argument videos, and then from there you click on where it says the YouTube channel, and it'll take you to their YouTube channel, and you click on live. That's where you'll find the live stream when it goes live. All right. So I talked to the clerk's office yesterday to ask about rebroadcasting this. I didn't get any clear answers, and I looked through some of the rules that there were, at least that I could glean in a cursory review, and I couldn't see what the rebroadcast rules are. So I'm going to try to get more clarity on that because I'd love to be able to bring you audio highlights Friday morning as to what some of the arguments were. If I can't directly share the audio clips, then I will definitely work to just kind of encapsulate and distill down all of the arguments that there were in our Friday morning review. So a lot to come this week when it comes to litigation against Illinois' gun and magazine ban. Thanks for tuning in, and I hope I'm helping at least keep this all sorted for you. But again, this is the federal case. This has nothing to do with the state case. That's still pending in the Illinois Supreme Court, that case from State's Representative Dan Calkins. So, hey, follow me anywhere. Just search Bishop on Air. Twitter's a great way to get the latest updates. You can also find me on Facebook. Don't forget about the YouTube channel. Like, subscribe, whatever it is. Just make sure you're plugged in, and we'll keep you posted on everything in real time on those social media channels. All right, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and